Everyone, this week's video is on continuity of employment, an incredibly important subject in determining a number of employment law rights and in identifying whether somebody qualifies for certain protections such as unfair dismissal rights, calculation of redundancy payments and protection in other areas as well. Now, an employee's continuity of employment will be severed if there is no contract in place for a complete week ending with a Saturday that does not contribute towards continuity. So if we have a week in the calendar where somebody is not covered by a contract of employment, the default position is that there is a breaking or a severing of the continuity, and that period of continuous employment will start again if the employee subsequently rejoins their employer. Now, the government is planning to extend this so that there is a gap of 4 weeks that is required rather than just one, seemingly to avoid tactics by employers to try and stop-start employment and to prevent employees from accruing certain rights. Now, importantly in this video, there are exceptions to that rule on continuity and breaking periods of continuous employment. We'll just examine two of them today, the first being a temporary cessation of work, which is essentially time spent absent from work where there is a brief cessation, so where work is stopped for a temporary period of time, but where that is it is expected ultimately that the employee will be re-engaged after that cessation. So there's a case of Prater and Cornwall County Council. A home tutor in this case worked on a series of temporary assignments under several employment contracts. The intervals between each assignment didn't break continuity because they were held to be due to a temporary cessation of work. It was always intended that she would pick up the next assignment within a short period of time and that she would then continue to be employed. So there are three requirements for this not to break continuity. There must be a cessation of work, so a factory might shut down for a short while due to a lack of work or even a planned shutdown. The employee must be away from work because of that cessation. So if they leave for another reason and are then re-employed, continuity is broken. They must be away because of that temporary cessation, and it must be temporary, although there is no statutory limit on the period of absence that can qualify. So there's a very relevant case to these principles called Fitzgerald, a welder that was dismissed for redundancy. He was re-employed 8 weeks later and was able to establish continuity simply because other welders remained employed during that period. There hadn't been a cessation of work, and the focus should be on that particular employee rather than the work in general. We also need to consider how long a temporary cessation applies for. I said there is no definition under the legislation, unfortunately, but there is a case of Ford and Warwickshire County Council. So a teacher in this case was employed for several years under successive fixed-term contracts. Those contracts were stated to expire in July every year, but the teacher successfully argued that the period of time between leaving in July and restarting again in September after the summer term was always a planned temporary cessation of work. It was always a plan that she would go back in the autumn term and carry on. And in that case, it was accepted that continuity was preserved in those circumstances. Contrast that with Berwick Salmon Fisheries and Rutherford, which I'm sure you're all aware of. The employees in this case were actually unemployed for longer than they were employed every year. And I think the tribunal lost patience with the argument at that point and said, this is more than simply a temporary cessation of work. And it seems the period of time that someone's away is therefore quite critical. The second element that we're going to explore, which does not break continuity, is where there is a break by arrangement or custom. If by arrangement or custom an employee is absent from work on any 1 week, that will still count towards continuity of employment. There is the case of Kerr and Marks and Spencer, which refers to there needing to be a meeting of minds. So both parties need to have addressed their minds to this period of time when the employee is going to be away from work, and essentially agree by arrangement that continuity will be preserved. Interesting in this case, the employee started working for Marks and Spencer in 1973. She took a 4-year career break under the company scheme between 1990 and 94. Made redundant in 1999, and the redundancy payment was calculated giving just 5 years of service. The employee argued that her service actually went back to her original start date and that the career break was a break by arrangement or custom and should count towards continuous employment. The Court of Appeal thankfully rejected that argument, so the redundancy pay was limited to 5 years. There had been no arrangement that the employee was intended to be still employed during that career break. She wasn't paid any holiday pay, and the company procedure made it clear that she had the option of applying for re-employment once the career break came to an end. So she had left, there was no intention to continue that contract, and there was the option of re-employment. So the principles in this case are essentially that it isn't an absolute rule that if an employee is away on any particular week, continuity will be broken. An employee can try to raise arguments that continuity has been preserved, particularly in the case of something like a sabbatical, a career break, a shutdown in operations. I have clients where it gets quiet in the winter, for example, so it's a very seasonal business. There is a rush for maybe 11 months of the year. Certain employees' employment is terminated for a month in the winter before it picks up again. What you need to be careful of is not creating that pattern where that happens every single year, because the longer that goes on, the more the employee can argue that this is either a temporary cessation of work, or there is essentially an agreement in place, an arrangement or custom, that at a certain point in the near future, the individual will be re-engaged again. If you do need any further advice on this area or anything in employment law generally, please do contact us. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.